can start the session. So, good evening, one and all. I once again invite you to a knowledge-filled, insightful discussion session organized by Ashwa Legal LLP. We are a boutique law firm having our presence in multiple cities spread across India. We have different partners who are presiding over various branches, and along with that, we have associates who are stationed at multiple locations. I would like to discuss and share with you all our associate policy. So the local CA firms, professional firms associate with us, where there is a mutual sharing of work and knowledge through this particular association. So any of y'all who are keen in taking up the association with us may connect with any one of the partners offline. Today, the topic that we are taking up is a very recent judgment relating to one of the most litigative principles in taxation history, which is the principle of mutuality. To start with this, I will request Shefali ji to give you a brief overview of this concept and its development until this latest decision, what we are going to deliberate on. Then I will be giving you a synopsis of this decision so that everybody present here is appraised of the recent judgment. And then the panel present over here, including say Dr. Avinash Bhaiya, would be sharing their deep insights on the various aspects of this decision and the way forward. So over to you, Shefali ji.
Thanks, Vishalji, and I would like to welcome all of our participants for this very important and important topic. And I would also like to congratulate Team Ashwa to pick up this topic at such an early stage. So the aspect of mutuality, it started long back. It's not a new topic. So the question is, if there are some people, a group of people with no intention of doing a business, so they accumulate some amount and they spend it to get the benefit of say quantity or something else. So whether they form two separate entities or not, and this question is not a new question. There was very old case of 1882 Graf versus Evans, where the first time it was held that the association and their members are not two separate entities, but they are the one person in itself. They are one. They are not two different entities. Then the second important question is that in GST, when we are talking about transaction, when we are talking about supply, so can supply be from a person to himself or herself? Is it even possible? Or there is a need of two parties? So there are two very important questions. The first thing is the associations and their members. Can we ever say that they are two separate different people? First thing. Second thing is whether there is a requirement of having two people. So if there is no requirement, then question will not arise. Even if there are no separate people, though no two different people in the association, even then the transaction will be there. So the second important and very important question is whether for a supply, which is the taxable event of GST, do we need two separate people, two separate entities? So one is the supplier end and the one is the recipient end. So as I said, this first question about the having these two separate entities of members and their association. So first judgment was not from India, as I said, it was from 1882 Evans versus Graf. When it comes to India, now there are some other questions also. So one other question is, there can be two kind of clubs or association. The first is which is not incorporated. So if it is it's just an understanding, but there is no formal documentation or incorporation, so there is no body at all. There is just an understanding between the people that okay, we will be doing this particular thing. Will it make any change if that particular association is formally incorporated? They have some documentation, they have the memorandum of understanding, like what exactly they will be doing, how much they will be collecting, how it will be spent, and what they will be going to do with the remaining amount. So if that is an incorporated body, will it make any change? So in that particular case, can we say that now because there is an incorporated body, there is a separate entity, so there are two different entities. So there were some earlier judgments on these issues also. So the principle applies, the principle of mutuality. It will apply even to the incorporated clubs. Here I would like to quote one very old judgment. It's 1940s judgment. It was Tribunal Working Men's Club and Institution versus McDonald's. Right. So in this particular judgment, they said that even if it is an incorporated body, even in that particular case, you cannot say that they are two different people or they are two different entities. So now the next question is, will this principle be applicable on the taxation institutes? So it will be applicable on the taxation institutes also. So there is a long history of litigation. There were many different judgments. And this issue is not just an issue of GST. So GST is comprising of both the goods and services. The same issue was also there in when there was the services and goods were separate. They were being taxed through the two separate enactments. So in the earlier regime of taxation, in the case of the sales of goods, uh, the government changed the statute in that case also, and the constitutional amendment was incorporated to include the association into the taxation ambit. So what happened? They changed the law. First of all, the statute was changed, and in the statute they entered an entry that okay, now the the sales of goods by the association to their members or vice versa, that will also be taxable. Then they lost the case in the Supreme Court, and after that the constitution was also amended, and the 46th Constitutional Amendment Act was passed, and an amendment was incorporated into the constitution. But the thing is, even after that particular amendment, the principle of mutuality is not overdone. It's still there because that amendment was not overdoing this. But there is one more important thing. So first thing was whether the corporations, whether the associations or clubs and their members are two separate people. Second thing is, do we need two separate people? And then third important thing is that if something is already covered in constitution, if something is already provided by the constitution, can we change it? Can we enlarge the meaning of that particular term by amending a statute? So when something is incorporated in the constitution, it is being incorporated on the basis of understanding of that particular term at that particular time, right? But later on, as the time changes, the term changes their meaning also. So if I take a simple example of manufacture, so when manufacture term was incorporated in its earlier time in the Excise Act, its understanding was completely different. But during a period of time when the decades and decades passed through the litigation, it got a completely different meaning. So the terms which are somewhere included in the constitution, they change their meaning. Now the question is, if something is already there in the constitution and there is an understanding about the term, right? Because it should be understood as per its understanding, its meaning at that time when it was incorporated into the constitution. So can later on, by changing the statute, can we enlarge the scope of that particular term? That is the another important question. So in this particular judgment, all of these points have been discussed. So I will not say yes or no at this point of time because it's going to be a very beautiful journey when our team will be going to discuss all of these points. So I think this was the basic about what important points were covered in this judgment. Now, Vishalji, over to you. You can give a brief about the different pointers of the judgment now.
Thank you, Sefali ji. So, just giving you a brief before this judgment about this concept. So, in GST, we all know there is a taxability on supply, and Shefali ji has pointed out one very important thing, that whether two persons are required for there being a supply. The answer is yes. This has been brought about in different other judgments as well. Now, the point is, when you require two different persons, then whether those two persons can be like club and its members. This is where the concept of mutuality comes in. This is not new only to GST. It was there in service tax era. It was there in sales tax era. It is also part of the income tax litigation. And that is where from all these pointers that we are going to discuss today has been incorporated into this judgment. So giving you a brief, 1st July 2017, we had GST. This particular point was nowhere highlighted. And we all presume that mutuality principle as it stands before GST law would continue in the GST law, which means that there should be no tax where it is a transaction between two persons who are mutually linked to one another having the same identity. This was reiterated in a very famous decision of Kolkata Club. However, immediately after that decision, the lawmakers used their legislative powers to amend the provision of the GST law, whereby they amended the definition of supply, even in the definition of business that was specifically introduced. Most importantly, in the definition of supply, they brought in this particular concept with a particular phrase, activities or transactions by a club with its members. So even they somewhere overrid the concept of supply, which is the base of the GST law. And most importantly, an explanation was added in this section 7.1 clause AA, stating that any judgment or decree which has been pronounced shall not apply. And this particular amendment making the transactions between clubs and its member taxable shall apply retrospectively from 1st July 2017. This was the amendment post Kolkata Club judgment. So again, the turmoil started. The biggest challenge was that how can we go back and pay tax for the earlier period when it was a set precedent that mutuality will always persist and there should be no tax on mutuality, which was also upheld in Kolkata Club. And this is where the entire turmoil started. And we are having this very famous, or I'll say today, the most discussed decision of IMA. So let me just run through with this discussion. So there was firstly a writ filed by IMA in which a decision was passed by a single judge. And that decision, which had part thing favorable for the petitioner, that is IMA, part thing favorable for the department, that writ decision was challenged in writ appeal by both parties by filing separate writ appeals on the different aspects of that writ decision. So where the petitioner was not comfortable with one part of the decision, he challenged in the writ appeal, and where the department was not comfortable, it filed the appeal on that particular aspect. And that is how we have this particular decision, which is of writ appeal by the respective court. So this is the citation, just if anybody would like to go through the details of the judgment. So I'll be running through the key aspects of this judgment, which are the key points that are discussed in this particular judgment, so that it will become a basis of our today's extensive deliberation. So broadly, if I have to share with you what are the brief facts. So as I mentioned, there was an action on the IMA by the DGGI, which made them pay tax on the activities between IMA, which is an association or a club, along with its doctors. The IMA is running various schemes for the benefit of the doctors, and there are different types of contributions flowing into IMA for these particular schemes. This is what the DGGI intended to tax. Now, in relation to this particular point, the IMA challenged the constitutionality of the amended provision as I was explaining, 7.1 AA was introduced, making it taxable retrospectively. This is what was challenged by IMA. And in the particular order of the single judge, the honorable judge upheld this particular point, stating that, I'll just read the key points. So the honorable single judge, where the writ was filed, found that there was no merit in contentions of the petitioner as regard manifest arbitrariness of the statutory provisions are there. So the learned judge found that the retroactive operation given to the amendment could not be legally sustained on the principle of fairness. So this is one part. It is therefore that the writ petitioner is impugning the portion of the judgment of the learned judge that dismiss its writ petition, whereas the union and the states are impugning the latter portion of the judgment that set aside the retrospective operation. So there were two parts of the judgment, one in the favor of the petitioner and one against the petitioner, that is in favor of the department. So both are now contesting in this writ appeal. Now in this particular writ appeal, what I would like to bring to light before we go into the in-depth deliberation is what are the key pointers from the submissions of the petitioner. So most important aspect is the aspect of mutuality. As was highlighted by Shefali ji, this very old judgment of Graff and Evans has firstly established that the identity of club and members is same, they are one and the same, and there is mutuality. Second important thing, this was also talked about Shefali ji, is that the principle of mutuality applies even though these clubs are incorporated. Then the third aspect is that the principle of mutuality is also upheld. It means that there should be no tax implication, and that particular concept of mutuality applies even to taxation laws. Now, these are the background judgments which has, you can say, created that particular legal dictum that the principle of mutuality is always to be upheld and there should be no tax when there is a transaction mutually between club and its association. Then comes the second interesting point that these are all foreign judgments, whether they would apply in the context of India. Again, this has been upheld by the Honorable Supreme Court in this particular given judgment that it is well accepted even in the framework of our Indian taxation laws. Next, very important judgment, again in relation to Indian taxation laws, is that incorporation would be irrelevant. So even where the clubs are incorporated, they cannot be treated as a separate legal entity, separate from its members, and that they can do any type of business. Further interesting aspects relating to the mutuality concept is that there can be no transfer between a club and its members. Most important. See, we are evolving from the pre-GST era when erstwhile we had the service tax laws. In fact, prior to that, we also had the sales tax law. Now, there is a history of amendments, which was also touched in by Shefali ji. So, there was a constitutional amendment 46th, which tried to bring tax on this particular aspect by bringing in the 46th constitution amendment in the perspective of the sales tax era. Now, interestingly, the mutuality concept survives even after the 46th amendment because the 46th amendment is not applicable to services. This is the most interesting point to be kept in mind, that even though the constitution was amended to allow taxability on sale of goods between a club and its members, but it is limited only to the perspective of goods, and it is till date, it is not covering services. And this was the basis on the basis of which the famous judgment of Calcutta Club rested, which said that despite of 46th amendment, still when we come to services, there will be the concept of mutuality and there should be no taxability. I'll just read out an interesting para. So the Honorable Supreme Court in the state of West Bengal versus Kolkata Club emphatically held that the principle of mutuality continued even after the 46th amendment. The said decision also recognizes that the law has always been that the principle of mutuality extends even to incorporated clubs and not just to unincorporated clubs, and that the 61st Law Commission report, which preceded this 46th amendment, had not appreciated this. Now, going a step further, there is another famous decision of Ranchi Club, which was also referred in the Kolkata Club in para 76, which recognized that the position in law was there could be no service between a club and its members. So despite of the 46th amendment, the point which is to be kept in mind is the constitution does not overrides the mutuality principle when it comes to provision of service by the club to its members. Now, moving ahead, with respect to this particular writ appeal, an interesting point of discussion was relating to the aspect of supply. So when we all are talking about GST, we all know that the taxable event in GST is supply. Most importantly, the definition of GST, which is provided by the Constitution, says that GST is a tax on supply of goods, services, or both. Now, the question is where the Constitution has limited the scope to supply. Can a legislative amendment enlarge this? This is where the discussion went ahead in this particular writ appeal. I would like to just highlight few important pointers which could be helpful to us even in our other arguments relating to other cases. So the scope of legislative power granted by the Constitution to levy GST is that such tax can be levied only when there is a supply. One second. And also, as was being highlighted by Shefali ji, what is very important to note is, see, this is where this law is different from the excise law. In excise law, even where you are doing removal from the factory, that is, there is no supply to any other person. In fact, even when there is a captive consumption, there was a levy. So for the purpose of excise, and even for that matter, for the purpose of customs, there is no requirement of two separate persons. When I'm carrying my own luggage, I may end up paying customs duty if I'm going beyond the limits of the baggage rules. But when you come to the service tax and even today GST, there is a requirement of there being two separate persons. Now, this particular point has been discussed at length in this particular writ appeal judgment, and I think everybody should take note of the important pointers. So what is being argued is when the Parliament brought in this amendment in the form of 7(1) AA, that is clause AA, making it also retrospective, what the parliament did was that in order to overcome maybe this particular lacuna that they do not have the constitutional power, they, instead of using the word supply, they have used the word activities or transactions between club and its members. Now, this has also been discussed in this particular point, that can a taxation law enlarge the scope of the taxable event. Now, here, a very famous judgment we all know relating to the works contract taxability, when the sales tax law of the Madras state tried to bring in tax on works contract, it was struck down in this famous decision of Gannon Durkerley, saying that the constitution did not provide the rights to tax on this type of transaction because it is not encompassed in the definition of sale of goods. Similarly, where the law of GST is using the term supply, the constitution is saying, defining GST to mean tax on supply. Can you extend by the law itself without making a constitutional amendment? Can you extend this taxable event to include any activity or transaction? This is what 71AA tried to do. And this is going to be one of the important bases for the final judgment. Now, so what is further, sir? What a constitutional provision is aimed at is to be constituted based on the state of law then in force. To expand the scope of such a provision by a statute would be to overreach the constitution. So what has been discussed over here very beautifully is that yes, a legislature has its own powers, and obviously all are independent in democracy. Judiciary is independent, legislature is independent, and there are multiple decisions favoring this, that legislature has power to define various concepts. But what is very important is where the constitution has defined something very clearly, can simply by making an amendment in the statute, can you overreach it? Can you expand it? This is the most interesting point to be understood, even in terms of all other issues that we are facing in GST. Further, a second important aspect that was highlighted is when you read section 7.1, which deals with supply, when it is talking about supply, it is saying that what is supply? Supply means forms of supply such as sale, barter, exchange, etc., etc. Now, here what they are highlighting is that we have this concept of injusdem generis, that when something is not clearly defined or the words are vague or it is incomplete, then we have to fill in the gaps by taking the color of the words which are specifically mentioned. And all these words, supply, transfer, barters, all require existence of two persons. So even though 71AA wants to tax something artificially by bringing in that deeming fiction, it still has to satisfy the test of supply. And for satisfying the test of supply, the involvement of two parties is very, very important. And then it has further deliberated that only constitution has the power to expand what constitution has defined. No statute can expand what constitution has defined. This is a very important point. I feel that we should make a note of so that we can use it in all our other submissions. And last thing, which I already mentioned, that can a supply of goods and service, which is the concept of GST as defined by the constitution, can it cover any activity or transaction? This particular writ judgment says, no, it cannot cover all activities and transaction. It has to strictly fall within the parameters of supply. Then comes the second important aspect highlighted is relating to retrospectivity. So one is, can mutuality be overridden? The answer is no, at least with respect to services, because that is not provided in the constitution. Then the second aspect is, can you tax something retrospectively? Now, again, we all know that there are plethora of judgment which says that yes, you can tax it, but then it comes with certain conditions and it has to satisfy the test of fairness. So now here, some important judgments have been discussed, referring to the first one, that is Gem and Co., which is actually against the assessee. But in that one, very important thing that is discussed is that where a law is to be made retrospective, it can be made, but it cannot be unreasonable. And if it is unreasonable, it would be held to be unconstitutional. Further, a new levy cannot overturn a long established position. So when you are creating a new levy, the new levy should be within the four corners of what is the established legal position by the constitution. Further, it has been stated that, again, we can use this submission in many of our other replies, that where any such amendment is brought in, which is affecting the appellate's vested right to its fund, like here, if you are bringing in a retrospective amendment asking me to pay tax on something which is 4 or 5 years old, that is now practically impossible, because now I cannot collect that tax from my recipients because all those transactions are dead and gone. So can such a particular retrospective amendment be done? Again, this particular pointer says that it would be considered as violative of Article 19. See, these are all the submissions by the petitioners, and later on, many of these have been upheld in the final judgment. So, most important thing is that whenever there is a retrospective amendment, whether it will be acceptable or not depends on this very important legal dictum, that whether it was clarificatory or whether it is a substantive change. Now, the most important point is, can the law itself say whether my amendment is clarificatory or not? Because in this particular amendment 71AA, they use this word, it is clarified that. So indirectly, the law, when it makes the amendment in the form of 7188, it itself is trying to give the color that this amendment is clarificatory. But again, a very important judgment is quoted in the form of Union of India versus Martin Lottery, where it has been said that whether any amendment is clarificatory or it is a substantive amendment. So what is the difference? If it is clarificatory, it can be retrospective. If it is substantive, it has to be prospective. This is a matter of statutory interpretation and can be only decided by the courts. So the legislature does not have the power to define by itself whether its amendment would be clarificatory or substantive. Another interesting thing highlighted in this particular writ appeal by the petitioner is that 71A, which is the amended provision, itself uses this term deemed twice. This itself demonstrates that the pre-amendment position was different, and that the use of the word that they are simply clarifying is not correct, because you are deeming something. It means you are trying to create a new levy. Two most important pointers which I found in this particular judgment, which can again be useful to us, is that whenever there is a retrospective amendment, you can always dispute the levy of interest. You can always dispute the levy of penalty, because what was not there in the law at the start, by bringing retrospective amendment, even though let us say it is upheld, that it is constitutionally valid and it is clarificatory, can you still collect interest and can you make me or compel me to pay penalty? Some favorable judgments have been quoted. Now, coming to the last aspect of this particular entire writ appeal judgment, what are the final findings in the judgment? I'm just quoting it verbatim because this is the most useful part. So I'm just reading out what has been upheld. Firstly, the findings on the constitutionality of these amendments was discussed, and it has been held this: the concept of supply and service having been judicially interpreted as requiring at least two persons. So this is the bottom line, where the Honorable Court has accepted this fact that for the purpose of there being a supply and the erstwhile service tax service, compulsorily we require two distinct persons, two separate persons, a provider and a recipient. And despite of the 46th amendment, what has been discussed in this writ appeal, still services are not covered in the 46th amendment. So the mutuality principle shall sustain when it comes to supply of service between the clubs and its members. So they have even discussed the judgments which are against this particular point. And then the final findings are, we do, however, find that the statutory provisions impugn, that is this 71AA and the definition in the definition of business, in these proceedings suffer from a definitive lack of legislative competence. Accordingly, the provisions of 217E, that is the definition of business, talking about clubs activities, and section 71AA, deeming that the club activities are taxable, and the explanation thereto, and the provisions, etc., etc., are declared as unconstitutional and void, being ultra vires the Article 246A, that is the enabling article for levying GST, read with Article 366(12)A, that is the definition article, and Article 265. So this is the most important part relating to the applicability of retrospective amendment. So, relating to retrospectivity, then they finally concluded that if we are concluding that there can be no tax because the amendment itself is unconstitutional, then there is no point of discussing whether retrospective should sustain or not. Still, in the concluding para, they have said that accordingly in modern times, the state is obliged to offer justification for all its action that touch upon the constitutional rights, fundamental rights, and otherwise of the citizen. We do not find any such justification for the retrospective operation of the impugned statutory provisions. So despite this was not required to be discussed, because once they upheld that the amendment itself is unconstitutional, still they have given these concluding remarks. So this is in nutshell the entire judgment of IMA. So myself and Shefali ji has tried to create that background so that now we can have a fruitful discussion on this entire concept of mutuality vis-a-vis the GST law and the way forward after this judgment. I I'll request Avinash Bhaiya to share his pointers on each of the aspects of this judgment so that we can open the forum for further discussion. Avinash Bhaiya, are you there? Ma'am, would you like to share your insights on this till the time he can connect?
So, Vishal, I will say in this particular judgment, there is still a long way to go because first step is Supreme Court. What will be the fate of this particular judgment at the level of Supreme Court? Then second thing will be it will take a lot of time. So, like, what should be the course of action for the entities who are falling under this criteria? Whether they should charge the tax or pay it, or they should not be charging the tax. Now, that's a very complex question. The reason being that if they are not charging and after say 6, 7, 8 years, but because as you have seen in the case of safari retreats, it took a long period from Odisha High Court to Supreme Court, right? And at the level of Supreme Court, the judgment it entirely changed. If you will see the judgment of the Odisha High Court in Safari Retreats, it had many points, right? But at the level of Supreme Court, the entire judgment, entire discussion changed, and it was just given on a very small point, and that was also retrospectively changed by the CBIC. So now the thing is, what should be their course of action for those periods? Whether they should pay the tax or they should not pay the tax. Now there is problem in both of the course of action. If they pay the tax and after that there is something against them, or say even in favor of them, but then CBIC will say that okay, we will go with the as is there is situation. So whosoever has paid the tax, we will not refund them. But for the particular people who have not paid the tax, they can go with that. That's a different thing. Now the another thing is they are not making the payment of tax, and after some years the decision against them, or even if it's favorable, but there are some retrospective changes incorporated into the constitution because at many times they have changed the law, but it is also possible to change the constitution, and constitutional changes can also be retrospective. That is another issue. So I think this particular matter will become the matter of litigation. Like I will say, many cases will fall under it. Some of them will be the small organizations, but some of them are actually very rich and very I will say money centric organization, which will be having a huge liability of tax. So what should be the course of action? That will always be a very important question in this matter. I think Avinash is there.
Yes, yes.
Yes. It's over to you, Avinash.
Uh, I think most of the things which is there in the decision has been beautifully dealt with. The only thing that I would like to address here would be it all depends how we read a particular judgment and from which context or what context we are reading that particular judgment. As per me, this judgment certainly speaks about the retrospectivity, the leviability. But when we look into the original scheme of the law, or rather the basic structure of the law, and the scope of supply, which is there in section 7(1)(a), it nowhere says that there has to be two persons. If we read 7(1)(a), it says by person for a consideration. So therefore, that question is always there, that whether to fall within the scope of supply, there is a necessity of two persons or not. Then the argument of the other side, when it comes to clause 17 of section 2, the way and manner it was already incorporated in the law, and that is not amended. That was there from the 1st July 2017. 71A was there from 1st July 2017. 71AA, certainly they brought in this, I'll not say purely for the purpose of negating the impact of Calcutta Club, but to certain extent to clarify the litigative aspect of the services performed by a club or association to the members. And therefore, there is an argument placed by the other side wherein they are saying that section 71A and 217 clause E, that means clause 17 of section 2 and subclause E of thereof, which deals with the provision of services which was to be included in the term business, is there existent from 1st July 2017, and therefore there is no argument which rests with the petitioners or the appellants so far as the concept of mutuality being brought in under the TextNet retrospectively comes. So therefore, that argument has not been dealt with in quite a detail. Yes, the other submissions have been dealt with in this judgment very fairly. Now, since it is a judgment, the question comes, what about the tenability? And at the same time, the question also comes, what about the applicability and reach of this judgment? So we all are aware that it is a writ court which has declared a particular provision as an unconstitutional, ultra vires, the provisions of section or ultra vires article 265 of the law, which is one of the most important viruses declared as ultra vires by the court. It has a far-reaching impact because now it is applicable across the country. It's a writ order quashing or declaring a particular provision as an ultra virus, and therefore it is not only applicable to Kerala, but it is also applicable across the board, unless there is a contrary judgment of some other high court, which unfortunately or fortunately till date is not there. So therefore we can very well presume, as that and rightly said by Shefali ji, can very well presume that there are going to be a lot of litigations in and around this particular question. But finally, whether we are going to see the light of the day, whether we are going to really get a favorable order from the apex court, because we cannot now sit idle and say and sit happy and say that now it has been declared as ultra vires and therefore it will sustain. It will be tested by the apex court, certainly. And when it will go to the apex court, in the entire judgment, there is no whisper about VKC footsteps. Now, VKC footsteps is a judgment which is, I would say, one of the most celebrated judgment and a path embarking judgment for all the times to come so far as GST is concerned. And therefore, without considering the arguments and the way and manner in which the apex court has laid down a law in VKC footsteps, I am of the view that no judgment is going to sustain. The judgment has to be tested from the guidelines, from the views and observations of the apex court as held by the apex court in VKC footsteps. That is, as per me, one of the most prominent, because Article 279A cannot be ignored. The constitutionality of a GST council, the meetings thereof, the decisions which is on the basis of the majority must be taken into consideration. So therefore, my only understanding, reading a particular judgment is okay. It is having a far-reaching impact, that is also certain. But I am of the view that maybe tomorrow it may not be sustainable. Tomorrow this judgment may not be affirmed and upheld by the Honorable Apex Court. This may happen, although this is very preliminary at the stage of commenting this, but whatever I have read, there are a lot of points, there are a lot of things on the basis of which I can say that it's a per incurium judgment. It will not have a long life. But yes, the judgment which was given by the single judge, by a single bench, which says that any retrospective amendment is within the, I would say, the legislative powers of the statute, and therefore the statute can have a provision which has the impact, or rather the effect, from a retrospective date. But the most important is a penalty cannot be levied retrospectively. And similarly, a tax which is taking a color and shape of a penalty at a later point in time because of the retrospective amendment is also not sustainable. Meaning thereby, like if we read the judgment in the initial part, there are social causes which are being reflected in the order, which has been argued by the learned counsel, one of the legends in the profession, Shri Arvind Dattar. And the way and manner it has been presented before the courts, it seems that the learned counsel was trying to point out that there is no business or profession here. It's only a social cause because of which IMA is there. And therefore, now taxing IMA on a retrospective basis, wherein no collection of tax has been done, and it is merely for the social benefit of its members, will even if the tax is there, even if there is no interest or penalty, then also I would say the tax is in the nature of a penalty. And therefore, it is said that it becomes a confiscatory provision. And since it becomes a confiscatory provision, the retrospective amendment must go. It can be made prospective. It may sustain. Even the Honorable Apex Court may say that. And we have also faced about the Vodafone issue. We have all seen what has been done in that. So at this point in time, it's not appropriate for me to comment on anything. But yes, certainly, these are certain food for thoughts which I was having. Because this judgment seems to be like बहुत ऊपर से है. It has not gone into that deep. For example, they are harping upon the deeming provision. The words "it has been clarified," notwithstanding any law in force. In all those explanations, they are trying to interpret that. But the mute question is, when 217E was there, when subsection A was there, when subsection 1 clause A was there, which speaks about by person, whether the requirement of discussion qua these provisions was there or not. There is no discussion. There is no rejoinder, wherein the other side has argued, but there is no rejoinder. So I'm of the view that that may come in our way when it goes to the Supreme Court. So it has to be tested in future, and let's see how it happens and how it proceeds. But yes, for the time being, it has been struck down. It has been declared as ultra vires, and therefore we can be. I would say we should not be complacent, and whatever planning we have done after the implementation of this law or this amendment, we should proceed with that. We should continue proceeding with that and wait for the examination and the result thereof from the Honorable Apex Court. Now, so far as the past period is concerned, I think this amendment is applicable from 1st January 2022. Before this, that is 31st December 2021, whatever was the liability or whatever is the liability being casted on us on the basis of the inclusive receipts or whatever, we can certainly contest that. And I am of the view that if the wisdom will prevail and we are able to convince the courts, and we are also able to point out the social causes and the impact of this liability casted on us on a retrospective date or from a retrospective date may go away. That may be considered by the courts and it may go away. But when it comes to the legislature, the formulation of the legislature, then certainly I'm of the view that legislature have all the powers. Now, when it comes to the discussion about the constitution and the enlarging the scope of the constitution, I think lot of things are there to be tested so far as that is concerned. I was having a brief discussion on that also, that how the enlarging of the scope is there and what is the background of it. We'll do it some other time. We'll have another session on this entire this thing from my perspective, and we'll try to discuss that. Not from the or not from the perspective of discussing this judgment, but from the perspective of understanding the context of this judgment, that how it can be dealt with and how it has to be dealt with in future. But my suggestion today would be, don't get complacent, don't be happy that this is a judgment which has struck down. Let it be tested at the Supreme Court. Let the Supreme Court decide on this. Certainly it will invite a lot of litigations, and therefore whatever is being there from 1st January 2022, whatever you are collecting and paying, or if not collecting and paying out of your own pocket, please continue that, maybe under protest now. You can say it is being paid under protest, so that there is no interest burden, there is no penalty burden in future. That is the only, because every association has some or the other social costs. That is the only thing that I would like to share. Yes.
Excellent. So I believe the major question that is there with the participants, that what is the way forward, has been answered. So we cannot be complacent just considering that there is a favorable decision like how it has been circulated on the WhatsApp. Instead, we have to go into the actual analysis of how it can impact and maybe how it may be having the future. So I think this is a very good insight by Avinash Bhaiya. Anything else? If any participant has a specific question relating to this, you all can put in the chat box. We still have around 5-7 minutes where we can take up your questions relating to this. So if anybody wants to ask any particular question, you can put in the chat box.
Vishal, now I have seen in some of the LinkedIn posts, like some people are raising question on the distinct person also. Now they are saying that if there is the requirement of two different people, so the definition of person in GST doesn't even include a distinct person, and it doesn't say that any person under the same PAN registered that is given in section 25, but the definition of person itself doesn't include it. Now they are raising the question on this thing also, that there is a provision that if there is a distinct person of you, you are required to pay the tax with the on the transactions with the distinct person, and that too without even consideration. So that is another issue that is arising because of this judgment.
Yeah, but I think in the start, Avinash Bhaiya has pointed out that whether 7A requires whether there is a requirement of two persons. So even if we have to discuss on this point of whether the distinct person can be two persons, is that whether there is a requirement of two persons.
But that's very interesting question, because it says that when any person is supplying like anything for consideration, so is it possible for a person to do something for himself and for consideration? So I'll be playing two roles. I'll be doing something and then I'll be paying the consideration of what I have done to myself.
In fact, this is what is my question also. So I thought I'll put it at the end. So Avinash Bhaiya, so when you are saying that maybe 7.1 is not specifying that there has to be two persons, but when it is also specifying that there has to be a consideration, that same point, how can I pay consideration to myself? And that is why I think we link it to Schedule 1 distinct person, that it can be without consideration also. I think this is my understanding. Yes, Avinash Bhaiya.
Just one example I can share. A one-person company. It's a company. If I'm drawing a remuneration as a director, whole-time director, that becomes a salary. If I'm also providing some additional services, say for example, as a chartered accountant, as an advisor, or maybe any services. Now we are not going to the legality, whether it can be done, whether it can be provided or not. Certainly, a chartered accountant services may not be provided, but an advisory certainly is permissible. And I'm charging something extra. Or let's say I'm renting out a property to that particular company and I'm charging a rent. Can we say that there are two different companies? It's a one-person company. I don't mean that it is an ROC registered company. A proprietorship, I can certainly charge if there is any embargo. I don't find any embargo. I can certainly raise an invoice as an individual to my proprietorship firm. And therefore, in that case, the applicability of GST is certainly there. So there can be a lot of examples wherein even a single person can have some consideration in a different capacity, but that will not make him as a distinct person. That is what I'm trying to say. Distinct person, it's very clear. Schedule 1, everything is very clear. But when it is not a distinct person, even in that case, I can have certain situations wherein I am billing to an organization which is so-called proprietorship firm, a separate identity as per me, not as per Income Tax Act. Then in that case, certainly the applicability of 7(1)(a) is there. So likewise, it's not about the members, it's not about the club. It's about the scope of supply. If it is so broad that even one person can be included, then the argument differs. Then the argument on the basis of which this judgment has been pronounced will have a different flavor altogether. That is the only food for thought which I am sharing. I am not saying that this judgment is wrong. Even if I would have argued, I would have also argued on the same lines. But the other side's arguments, which is pertaining to 7(1)(a) read with 217(e), has not been dealt in the order. To an extent, the court has not tried to clarify why they are not buying that argument. They are merely saying that retrospectivity we are not dealing. Now, so far as the taxability is concerned, we cannot allow any person or any legislative authority to not align with the judgments of the Supreme Court, which has been passed in last 7 decades, following the same principle. And wherein they are emphasizing that had it been the purpose, they should have amended the Constitution. And after amendment of the Constitution, then the statute could have been amended. That is what is coming out from reading of this judgment. But within the law, if there is a provision of 217 small e, why that has not been dealt with? Because that is also within the purview of business. And it says for a consideration in course or furtherance of business. So even two distinct persons or two identities, one club and one association of or one person, why they cannot fall into 217E when specifically that clause is there? If I'm let me just try to read that. It says business includes provision by a club, association, society, or any such body for a subscription or any other consideration of the facilities or benefits to its members. Now the mutuality concept was there. Calcutta Club was there. They amended the law to negate that Calcutta Club. It is very apparent now. So the only point is when it was being argued and when they have said that it was a prior thought, we have considered this and therefore we have included the services of club to its members as a business service. And we have incorporated everything in 7(1)(a). So 7(1)(a) is merely clarification. Even if it was not there, it was taxable. That is their argument. And the court, unfortunately, I have not read, maybe I would have missed it, but I have not read anything specifically commenting on this particular contention of the tax authorities or the department. That is the point which I'm only raising. Now it needs to be tested because to that extent, and so far as the other things are concerned, it is a per incurium because when I said VKC footsteps, it was supposed to be considered in GST. It has not been laid before the court and it has not been considered. So that also because whether now how a legislature is being formulated under GST. The prime role is not of the parliament, but the prime role now is of the GST council. And therefore the GST council minutes, why it was amended, what was the purpose of amending this? Everything was supposed to be there in the record, in the judgment. It is not there. So therefore, to that extent, it is per incurium, and therefore it will be tested by the Supreme Court. But I am with the court, or I am agreeing to this when it comes to retrospectivity. From day one, I am of the view that retrospectivity cannot be prejudicial to the interest of the taxpayer. It cannot be in the way of a penalization or a penalty.
Avinash for our listeners, because many of our audience are chartered accountants and not the advocates, can you please just like for 1 minute you will explain what is the meaning of per incurium and like how VKC footstep will make a change in this particular scenario?
Per incurium has many facets, but the very simple way of explaining this would be when a judgment is written without considering a particular ratio, which is important to be considered in pronouncements of that particular judgment, that judgment becomes per incurium. For example, VKC footsteps have discussed in detail about the importance and of the decisions of the GST councils, the autonomous body and the powers which have been conferred by the Constitution of India. That is nowhere discussed. How the meetings of the council are important, the way and the manner in which the decisions are taken. The Constitution says that it has to be taken by a majority of 2/3 persons. All those things are never spoken, or rather never contended in the entire petition, or rather in the entire argument, in the entire order. So therefore, to that extent, it becomes per incurium, and therefore now it needs to be considered that whether VKC would be applicable or not, that doesn't matter. But whether those arguments were supposed to be taken, whether those minutes are important or not, whether GST Council, how they have perceived, why they have amended, what was the purpose of amending this, it was only for the purpose of negating, or it was for the purpose of clarification. For example, if we find in GST Council minutes that they say, although there is 217E, although there is 71A, still after Calcutta Club, we have to clarify this further. Then their argument of having 71A, having 279E from day one will be seen from a different color, because their argument is recorded in the GST Council minutes. But if the GST Council minute says, no, we have to nullify the effect of Calcutta Club, then in that case, the arguments which have been contended in the petition will become more relevant. That is just per incurium all about. Something which has been already settled, for example, Radhakrishna Industries, a particular issue has been settled. Now, if decision has been taken without considering that particular judgment, and that too adverse or in favor, that particular judgment will be per incurium. एक छोटा सा example देता हूँ, शायद उससे clarify हो जाएगा. Within an appealable period, if there is an alternate remedy, we can still file a writ petition. But if we file the writ petition after the lapse of the appealable period, that writ petition is not maintainable. That is the judgment of the Honorable Apex Court and the larger bench of Gujarat High Court. Now, if any writ is filed after, let's say, the expiry of the period of appeal, and that particular judgment has not been quoted by the other side, and the writ is entertained and given in favor of the petitioner, then the other side can approach the higher forum, and then they can say that this particular judgment, or they can go for a review wherein they can say that this particular judgment which has been pronounced without considering a settled law of the Apex Court is per incurium, and therefore it needs to be reviewed. That is what is per incurium all about. I hope I'm clear.
Even though they may not have taken this position in their present writ also, still they can go to the higher forum taking that position?
Correct, because that is also already a settled position. For that, it is not required that they should have taken in the erstwhile or in the earlier proceedings. No, it's not required because it is already settled.
Great. I think we had a very insightful discussion on various aspects, including the last point of incurium has to be understood and how it impacts. So I think since there are no questions, we can conclude our today's webinar. So on behalf of Ashwa Legal Advisors LLP, I thank all the participants for always being present in great numbers, showing your inquisitiveness in all such technical issues. See, for regular updates and all, we always find people gathering, but for such technical things and staying there with us for the entire 1 hour and understanding all the nitty-gritties, I think it is commendable for all the participants. Along with this, I thank Shefali ji, Avinash Bhaiya, and all people from Ashwa Legal who have been part of this particular webinar to make it a success. And we are again meeting tomorrow for our scheduled monthly webinar. This was an add-on because of the recent judgment, and we felt that it is important to discuss all these nitty-gritties. So we added this besides our regular schedule. Tomorrow we have a very important deliberation on the maintainability of the concept of cross charge. So if you all remember, we already had the precursor session to this. That was the ISD part, the provisions of ISD, the new amended provisions, its impact and how it will be applicable. Tomorrow, we will go ahead as to, because many times when ISD is discussed, cross charge comes complementary, because many times we have sessions called as ISD versus cross charge. In fact, tomorrow's session also we have named so, but the major point that we'll be discussing tomorrow is the maintainability of the concept of cross charge. That is, we are going to understand the legal implication of the Schedule 1 entries read with the definition of supply. So that would be again a very in-depth discussion oriented and insightful session. So I again invite all of y'all. We already have registrations exceeding 100. So I'm sure all others who are present over here and have not registered may please register with the link so that you'll have the details of the webinar. And looking forward to again connecting with you all tomorrow and again for all our further sessions. Also requesting that if you all have any particular topic where you feel that Ashwa Legal can be of value addition, can add to you as knowledge partner, please help us by sharing those topics or issues. We will be definitely planning a session on the same. So with this, I declare that our today's session is closed. And thank you once again, everyone. Thank you, Avinash Bhaiya. Thank you,
Sure.
Shefali ji.
Thank you,
Thank
everyone.
you, Rashji. Thanks, everyone.
Thank you.